Professor Patrick Honnebier is one of the few aircraft finance lawyers having obtained the benefits of both worlds. While he is a long-standing academic, he also has vast practical experience in realizing international aviation finance and lease transactions. The combination of extensive scholarly legal knowledge and its direct application in practice makes him a well-rounded aircraft finance lawyer. As an instructor for the course Aircraft Acquisition and Financing, he joined the International Air Transport Association in May 2019. Besides, Professor Honnebier is one of the founding members of Rep Law Aviation and based in Amsterdam. He advises major manufacturers, banks, lessors, and airlines in relation to international financing and leasing of aircraft, helicopters, and engines. At the Master of Laws program in the University of Mississippi School of Law, he is the professor of international aviation financing and leasing laws. As a guest lecturer, he addresses the conflict of laws rules covering aircraft financing transactions at Groningen University, the Netherlands. He is the author of numerous articles being published in all the leading air law journals. Frequently and worldwide, he is a speaker at international aviation finance and lease conferences. I invite you, Professor Patrick Honnebier, to speak on the topic today, that is significance of properly implementing the UNITWA system in financing the aircraft.
All right, thank you very much for the extensive introduction. I'm very grateful and honored to be here today to talk to you about aircraft financing and leasing in general, and specifically about the importance and significance of properly implementing the UNIDROIT system, which has been discussed by the previous speaker so well, Mr. Hamza, my colleague Hamza. And then I also would like at the end to address that considering this issue, the laws of my country, the Netherlands, are intending to facilitate this matter since April 1, the 1st of April 2020. Can we go to the next slide, please? Yeah, this is me, obviously. I would like to add one thing about the University of Mississippi School of Law. We have a Master of Law course in Air and Space Law. Can you go back, please? A Master of Law. This is even making me more confused. A Master of Law in Air and Space Law. And as you mentioned, I am the responsible professor for international aviation financing and leasing laws. And that is a full semester course. We teach right now, this week, for example, Mondays and Wednesday, 1.5 hours each lecture. And I'm doing this already 7 years since I left Leiden University. And why am I bringing this up? It is because, well, the other academic institutions are not providing for this type of course. They are not providing for it. And therefore, those of you who are keen in getting to know more about international aviation financing and leasing, transactions, you may look more into the possibilities which we offer to lawyers, law students, but also non-lawyers. Okay, thank you. Can we go to the next slide, please? Right, I'm going to focus today on India, on this particular aircraft, which is right now grounded at, as you can see, at Biggin Hill Airport in the United Kingdom. It is a corporate aircraft. It is a Bombardier, manufacturing serial number you see, registration India VTRAK Okay, so keep that in mind, please. I focus on the Indian situation. I'm not bashing India at all. That's not my intention, but it is a pending case, and I think it is of great importance because in this case, the Cape Town Convention applies, and the aircraft is still grounded for 10 years. And that will, we all agree, I'm sure, is a period which is just too long. Should not be like this, but it is like this. So India and Cape Town Convention, that's what we are addressing right now. Can we go to the next slide, please? This airplane did belong to a certain gentleman, as you can see here. Those of you from India may know, if you're not that young, this gentleman, the Indian Premier League cricket boss, Mr. Lalit Modi. He was flying around India and abroad in this particular aircraft. Next, please. What happened? The practical aspects. Okay, it is a long story, but I'll make it as brief as possible. The parties in this case, I think, are very interesting. Peel Aviation, Ireland, leases to a lessee, Golden Wings, in India in 2008, this aircraft, this specific aircraft. All right, almost simultaneously, corporate aircraft funding, the mortgagee in the United States, the bank, loans and gets a mortgage of $14 million in this aircraft from the mortgagor PAL, from Peel, all right? India ratified the Cape Town Treaty on July 1st, 2008, all right? Both parties, both stakeholders, the lessee and lessor, defaulted under the lease and mortgage agreements in 2010. The lessor is the mortgagee as well, you can imagine. Now, so that was not a nice situation. In 2001, already in April, the aircraft was exported from India. It was taken out. It was flown out of India in 2010. All right. Now, as I said, aircraft grounded at Biggin Hill Airport in the UK as from July 23 to 2010. That is quite a long time. And why? Because the Directorate General of Civil Aviation, DGCA, for those of you not from India, the DGCA is Directorate General of Civil Aviation, Department of Civil Aviation, refuses to deregister the aircraft from the Indian registry. Now, is this a good thing or is this a bad thing? I don't know what you think right now, but I'll try to explain what happened. But I think anything resulting to 10-year grounding of one aircraft is a no-no. And this, by the way, also is in a way valid for the Jet Airways case. The Jet Airways, insolvency situation right now in India. I don't know how far it is today, but one of the aircraft of Jet Airways has been grounded since April or May, possibly, I'm not exactly sure right now, 2019, for longer than a year at the airport of Amsterdam, where I am located right now. I'm located in Amsterdam. All right. And why was that? Same reason. Department Civil Aviation India, DGCA, refused to deregister also that beautiful Boeing 777 aircraft for a year. Now, again, in my book, 1 year is too long, particularly assuming that the Cape Town Convention applied in the Jet Airways case and also in this case. All right. Why did the Department General Civil Aviation refuse? Because the Directorate Revenue Intelligence of India, the DRI, was arguing that the aircraft was leased and involved a big tax scam involving the gentleman I just mentioned earlier and his group of people around him. So that was the reason why the revenue people of India asked the civil aviation department not to deregister. And they did this on several occasions. Consequently, 10 years that certain corporate aircraft. I can't stress it enough because I think it is ridiculous. Can we go to the next slide, please? What happened in India in the meantime? All right, there are two corporate aircraft funding versus India cases. India, different government agencies. All right, the first one, corporate aircraft funding versus Union of India, March 14, 2013. Court in India uh, orders Department of Civil Aviation to deregister the aircraft as required by the applicable international conventions. Now, see later the Cape Town Convention, but I already told you that India adopted Cape Town in 2008, okay, on July 1st. So Cape Town applied to the situation at hand. You can still me, I trust. You can still hear me because I cannot.
Yes, sir, you're audible.
You can still hear me?
Yes.
Okay, great. Um, all right, that's the first case. So the court of first instance, if you know what I mean, did apply the Cape Town Convention, did explicitly, extensively address the matters which colleague Hamza just now has discussed in the previous presentation. The fact that the IDERA rule was applicable, that the Department of Civil Aviation didn't have a choice, it didn't have discretion, it should do its homework under the treaty. All right, but the court agreed. And at the end of the day, in its ruling, it said, yes, deregister. Nevertheless, the the tax people, in my words, appealed. The Directorate Revenue Intelligence versus the Corporate Aircraft Funding case, May 10, 2013. The Court of Appeal, in my words, totally ignores in its decision the applicable existing international conventions. Of course, the parties in this case, the stakeholders, corporate and aircraft funding lawyers, argued, Your Honor, or whatever they say in India to a justice or a judge, Your Honor, this is the case and this is the convention. The Department of Civil Aviation has no choice under the treaty. What happened, however, in its ruling, in its final decision, the Court of Appeals did not, at least in the least, mention the treaty. Didn't say anything about it, as if it didn't exist. All right. It just said Civil Aviation Department must decide in 4 weeks on the deregistration request and some more things evidently which should not have occurred. It should just have said, like the court of first instance, deregister. That's it. Dot. Period. All right. Later on, October 2013, Department of Civil Aviation, India, said to corporate aircraft funding, the bank, the mortgagee, aircraft will be confiscated. And again, it refused to deregister now on public interest grounds. Nou ja, that's not possible under the treaty. But anyway, that's what it says. So, in short, until today, it did not deregister the aircraft from India, as far as I know, unless they did it last week or something like that. But I don't think so. I doubt it. Okay. And the reason being these days, by the way, The reason being these days, as far as I'm told by my connections in India, lawyers in India, is that just like in the Jet Airways case, aircraft being grounded here for 1 year at Amsterdam Airport, the reason being these days, yeah, Department of Civil Aviation of India does not like it very much that the aircraft are exported and then uh, grounded somewhere else, and they get a request for based on an IDERA for deregistration. That's what I'm told. They just don't like that situation. Is that valid? I seriously doubt it. Okay, what happened recently or relatively recently? In 2019 in Ireland, there did arise, was initiated an insolvency court case. In 2019, corporate aircraft funding, the mortgagee from the United States, the bank, requests an Irish court for the liquidation of Peel, of the lessor. And that was honored by the court. So now Peel, the lessor, is bankrupt in Ireland. Irish liquidator was appointed in Ireland, and it's now supposed to take care of the bankruptcy estate, insolvency estate of the lessor. Well, first of all, it learns us that also lessors go bankrupt. Isn't that a novelty? How often do you hear these days that lessors go bankrupt? You don't hear that often, but they do go bankrupt. Often lessors are made in such a way as special purpose vehicles. They are called bankruptcy remote entities, that they can hardly go bankrupt. And why? Because in such a situation, they only have an asset, the aircraft, with hardly any debts. No staff, no this, no that, no that. Only income, lease money. So remote from bankruptcy. Nevertheless, we learn now that also allegedly bankruptcy remote lessors, special purpose vehicles can go bankrupt. That learns us this case. Now, until today, the Irish liquidator has not realized the execution sale of the aircraft, unless he is doing that today. But yesterday, as far as I know, was not the case yet. Can we go on, please? Right. What do international treaties say about aircraft deregistration? That is now important. Now, first of all, we start with the Chicago Convention, which is known to about all of us here present today, right? Now, what does it say? The Chicago Convention, indeed, traditionally, initially 1944. Don't forget, 1944 was a different situation from today, but it focuses on sovereignty and on safety and safety oversight. Nevertheless, when you look into the Chicago Convention 1944, it also covers economic aspects and title to aircraft. It says we need a new treaty covering title shift of aircraft. We need that, and that turned out to be the Geneva Convention 1948, which has also been addressed by our colleague Hamza. Okay, now what does it say in why is it important in regard to this case at hand and in general to aircraft financing and leasing situations? It says, and this is very important, an aircraft cannot be validly registered in more than one state, but its registration may be changed from one state to another, right? Article 18, that's it. But now, which term is now the most important term of this provision? That is validly registered. And that is so odd because it's not odd, this term, but what is odd is that the authors of articles writing about this provision, Chicago Convention, almost always, let me put it this way, 70%, if not 80 or 90, leave out the term validly. That's very odd. And so basically it means that you can have an aircraft, one aircraft like this one, registered in one other country or 10 other countries invalidly, but validly only in one. So the question arises, like in this case, where is it validly registered? That's what it is. Validly. Keep that in mind, please. Now, registration of aircraft and its transfer, so switching from registration, is based on local laws. So, in essence, what the Chicago Convention is saying is Article 1819, the registration and deregistration procedures are done, are made by the contracting states, right? However, the conclusion is that the Chicago Convention does not contain, and that's what we are talking about today, a deregistration procedure. It doesn't do that at all. It doesn't do that at all. So each state has its own good or bad deregistration rules. Now, unless a new self-executing ICAO endorsed treaty dictates no discretion of the contracting states, dictates a uniform deregistration procedure for all its member states. Can we go to the next slide, please? This has been discussed by Hamza, our colleague Hamza previously, but how many states? But look at the bottom, please. Self-executing Cape Town Convention provides in 7-9 member states, maybe Hamza, you know better if this you just told us, for a uniform legal regime which includes, where especially adopted, the IDERA provision must have been adopted by a member state, like India has done in 2008, a mandatory export and re-registration provision, which is solely documentary in kind, meaning that technical aspects do not play a role here. But why do I say self-executing Cape Town Convention? In states, like for example, in my country, the Kingdom of the Netherlands, and all its territorial units, the territorial units where the Cape Town Convention applies, treaties like this are self-executing in the sense that the contracting states, like in my country, do not have to do anything to make it applicable. Nothing. And that is why until recently, the Kingdom of the Netherlands and other states, same situation, don't have to implement the Cape Town Convention into their local laws. They don't have to do that, right? There's no need, unless they want to do so. They say, okay, treaties by definition have priority, and secondly, local laws which are infringing our treaties will not be applied, because it is a self-executing treaty, and we have agreed upon this, all the contracting states. Next slide, please. Can we go to the next slide, please? Thank you. Which Cape Town Convention deregistration process applies to the aircraft at issue? Well, as I said, the Cape Town Convention provides for a uniform deregistration procedure in India, Kingdom, Netherlands, Ireland, and the UK. Those countries are involved right now in this certain case, right? Still pending. It applies because they have adopted the IDERA rule. International interest was existing pursuant to the Cape Town Convention. Look at the court rulings which discuss it. And IDERA was validly lodged and received by the Department of Civil Aviation India. Okay, IDERA was recorded, right, by DGCA, DCGA, protecting corporate aircraft funding as the authorized party. When corporate aircraft funding asked for deregistration, DGCA had no discretion. It had to cooperate and swiftly, not waiting 10 years, not even 1 year like Jet Airways case. No, 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 no. The DGCA refused, and now in my country and other countries, this kind of behavior of government agencies which damage stakeholders like corporate aircraft funding, because an aircraft being grounded for 10 years costs a lot of money, will be a tortious act by the government itself, as we call a government tort, and therefore the government is liable for damages. And in addition, legally, the aircraft is not, or if you wish, in brackets, no longer validly registered in India. Consequently, because remember Article 18 and 19, every country can make its own registration rules, and there is no registration rule in the Cape Town Convention. So every state makes its own registration rules, like the Netherlands is doing too. So consequently, it can be lawfully registered in another country of the Cape Town Convention, which has adopted the IDERA rule. Now, there is no double registration in this situation, and the Chicago Convention is not breached. Can we go to the next slide, please? We're almost there, I think. What did the Netherlands introduce? Okay, well, the Netherlands, for certain territorial units of the Kingdom of the Netherlands, has adopted the Cape Town Convention in 2010. Now we have amended recently on April 1st, 2020, our registration rules. It makes it easier to register aircraft in the Netherlands in the case, assuming that, proven that, the Cape Town Convention applies, the IDERA rule applies. When can you now, since April 1st, register aircraft in the European Netherlands? No, not in the European Netherlands, in the Netherlands. In the Netherlands. Now, aircraft, when an aircraft is imported from another country, like from India, because it was originally coming from India, it was registered there, no more validly. But if it is important to register, not physically important, by the way, proof must be submitted that aircraft is no longer or not registered abroad. Or, and now it comes, that's what it is all about, is that the authorized party has duly asked the Department of Civil Aviation to deregister the aircraft, which is refused. Now, and then one more thing, to get domicile, to get a connection with the Netherlands, where the Cape Town Convention applies, the territorial units where the Cape Town Convention applies, to get a real connection with that, you must create domicile with that jurisdiction. So required is that the applicant for registration must be domiciled in the Caribbean Netherlands. Bonaire is one of the territorial units in the Caribbean. It is an island in the Caribbean, and that's so funny. It is an island, and it is a small one. It is not that big, but I mean, people in practice always talk about the Netherlands when they talk about Cape Town ratified by the Kingdom of the Netherlands. Oh yeah, it applies in the islands. Well, I never heard anybody say, the UK ratified the Cape Town Convention in the island of Great Britain and Northern Ireland. It's ratified in the island of the island of Ireland ratified. The island of Australia ratified. It's also a continent, Australia, but they are islands. So why on earth do they always refer to islands when the Cape Town Convention is discussed and the Kingdom of the Netherlands is? Very odd. In any event, what I'm trying to say is that you must create domicile in the Caribbean Netherlands, which you do by, yeah, let's say a special purpose vehicle, as discussed earlier what it is. And the aircraft must be managed, whatever, to lease it out again, and so on. Please note that it doesn't apply in Aruba, Curacao, and other territorial units of the Kingdom of the Netherlands where the Cape Town Convention applies. Can we go to the next slide, please? I'm almost there. Some concluding remarks. Practical consequences. Aircraft you do in practice, like the one at hand I'm discussing today, is you register it in the Netherlands, so not in the islands, quote unquote. No, therefore it obtains the flag, the PH flag of the Netherlands. They could have done so also with the Jet Airways Boeing 777. They could have done so since April 1st of this year. Later, it can be leased and registered in all other countries having adopted Cape Town and having made the declaration of IDERA. The new law can facilitate global deregistration. No country has done this yet. Registration implemented innovatively the Cape Town Convention, which could certainly create the issues that keep arising, and again, not bashing India. Other countries, I could mention at least 6, 7, 8, 10 others, but we are now having the conference in India, so I focus on India. Can we go to the last slide, I think, please? Yeah, if you are interested in this, if you have a problem like this, my law firm is the only team exclusively focusing on aviation law in all the units of the Kingdom of the Netherlands. We have been, personally, I've been as well very proud to be the expert legal advisor of the government of the Netherlands, again, the Netherlands, for the innovative implementation of the Cape Town Convention IDERA procedure. I'm very proud of that. It took us 4 years, you may know, to get this implemented, because you can imagine this was not done, as we say in the Netherlands, during one night ice on the river. No, 4 years, contact with ICAO, contact with other countries. That's so we are not alone, as if we invented something totally outrageous. Okay, unique aircraft registration, now yeah, that requires special knowledge, and we have got a special team for you. Next slide, please. Thank you so much for your attention. Sorry to be over time. Hopefully I was not the only one today. Hopefully you also were able to see me, because I can still see you move. So any questions are later on, I suppose. Thank you a lot.